Thank you, Vaughan. Good morning, everyone. When I was asked to put together a talk today about the current state of the South African construction industry and potentially where it's going, I was racking my brain for a heading. And some of the headings, I sat in Vaughan's office, and some of the headings we sort of discussed were things like, in the emergency room and out the door. Or on its way out. We weren't too sure about the current state. But I eventually came up with the heading, "The Times They Are Changing." And what it's about developments in our industry over the past 15 years, and then a very brief look into what the future may hold. So what's in the title? Well, as you may know, it's a song by Bob Dylan about times changing. And I thought it'd be germane to talk about it from this perspective, because we find ourselves in a position where many clients of mine will say to me, Euan, things aren't like they used to be. We never looked at the contract. When we did projects years ago, we never had problems. The contract stayed in the drawer, and we never had to rely on the contract. And nowadays things are so contractual and so different and so adversarial, and times are changing. So it's time to start embracing that and to look at what those changes are. Also, I thought that a lot of us have this preconceived idea of what construction law is. We all think it's claims for extensions of time and an additional payment, or disruption claims, or maybe maybe something like that, or maybe standard form contracts. And I think that defining what construction law is a lot broader than that. It takes into account things like health and safety legislation, the environmental legislation, and various other aspects of law as well. So in this talk, I'd like to also sort of show you, hopefully, what some of the boundaries are with regards to construction contract law. And then also the basis of this talk, some of you may have been to something similar previously. This is obviously a lot more detailed, but I've been talking to a lot of interest groups in recent times around what's going on, how things are changing, and the necessity for you to understand as role players in the construction industry exactly what the extent of those changes are. If you're not going to embrace the change, you're going to be left behind, and you will not be able to cope in the new construction industry. So with that in mind, I've looked at some of the highlights over the past 15 years. Some of you may think that they're the lowlights over the last 15 years. I want to discuss whether they've been good or bad for the industry. And then I want to look into the crystal ball, if you like, and try and forecast, although that's quite difficult, as Vaughan says, with the current predicament around our finance minister and other things. But to look at what might happen in the next few years. I think some of the things which are on our doorstep are quite exciting, and they're quite easy to talk about, but there may be some further changes as well, and maybe some changes which we would like to see, which may, in the full turn of time, turn out to be maybe a bit of wishful thinking. But any talk like this needs to start off at probably the most significant development in the past 15 years, and that's the Construction Industry Development Board, or what we refer to as the CIDB. Those of you who have read through economic policy in South Africa will know that it's a bit like a messy alphabet soup. We have GEAR, the Growth, Economic and Redevelopment Program. We have ASGISA, and we now have something called the National Development Plan 2030. Each of these plans, each of these policies sets out how the government intends growing the economy and developing and addressing the imbalances of the past. Each of them are focused on key areas of the economy, and each of them have a common characteristic, and that is that they place great emphasis on the role of the construction industry in growing the economy in this country. If we go back and we look at, there was a green paper which preceded the white paper, but in 1997, government released the white paper. The white paper was titled "Creating an Enabling Environment for Reconstruction, Growth and Development in the Construction Industry." And the purpose of that white paper was to set out the government's vision for an enabling strategy aimed at enhanced delivery, greater stability, improved industry performance, value for money, and growth of the emerging sector. And in order to put that policy into place, government passed the Construction Industry Development Board Act 38 of 2000, the CIDB Act. And that act provides, for the purposes of this talk, two very important things. Firstly, it sets out the establishment of the board, the CIDB. It then sets out in sections 2 to 6, and particularly section 4, what the objectives of that board are. And there's a long list of objectives. And they're important because they tell us exactly what the idea behind the Act is and what the purpose of the CIDB is. So firstly, the purpose includes the promotion, to promote the contribution of the construction industry in meeting national construction demand and advancing national, social, and economic development objectives, industry performance, efficiency, and competitiveness, and improved value to clients. Also to determine and establish best practice that promotes improved industry stability, improved industry performance, efficiency, and effectiveness, procurement and delivery management reform, improved public sector delivery management, to promote best practice through the development and implementation of appropriate programs and measures aimed at best practice and improved performance of public and private sector clients, contractors, and other participants in the construction delivery process. What's important is that in that little extract there is that many clients have seen the CIDB as something which only affects the public sector. There are exclusions to the CIDB Act, and those exclusions are primarily in mining and the petrochemical industry. But by and large, the CIDB Act applies both to the public and private sector. And that is important where we find ourselves at the moment, particularly with regards to issues around payment. To promote and establish or endorse uniform standards and ethical standards that regulate the actions, practices, and procedures of parties engaged in construction contracts. So there's a long list of objectives which the CIDB Act sets out. The next important section, the second part that's important, is section 33, which empowers the Minister of Public Works to enact regulations which are published in the Government Gazette, and they constitute a form of delegated legislation. So in order to give the CIDB some teeth, they've given it delegated legislative authority. They can pass regulations which are binding on the construction industry and those who act in the construction industry. So since its enactment and the formation of the CIDB, what exactly has the CIDB done? Well, they've provided us with various standards which address uniformity in procurement. We look at things which address procurement processes. We have standards which deal with how we tender for work, how tenders should be adjudicated, which standard form contracts we should use. There are codes of practice and various other documents aimed at regulating and bringing uniformity to the construction procurement process and how contracts are executed. It's established and maintained a register of contractors. So contractors register themselves, they get a grading, they have to keep themselves registered, and in order to qualify for various projects, they have to obviously satisfy a certain grading, and they have to be registered with the CIDB. And then based on the information which they glean from contractors, professionals, and employers, they also provide various industry indicators. Some of these industry indicators are taken out or carried out by third parties, and a very good source of these indicators is Professor Marks at the University of the Free State, who provides the annual CIDB industry indicators, which address things like client satisfaction, projects which start late, projects which finish late, payment practices within the construction industry, and various other factors as well. Has it worked? Well, in establishing that, I went online and downloaded the Minister of Public Works speech, which he delivered at the CIDB National Stakeholder Forum during March this year. And during that speech, he identified some of the good things which have happened. So currently there are over 130,000 contractor registrations, okay, at all levels. The majority of these registered contractors are black. There are more women and youth-owned contracting enterprises and more disabled people which now participate in the economy and in the construction industry in particular. That said, unfortunately, although this sounds like very good news, the majority of those registrations are at the lower end of the registration. That's where the majority of these organizations are. And not only that, despite the CIDB being in position and being in place for a number of years, one of the repeated problems is that a number of these contractors are unable to advance up the registration hierarchy. So they're staying in the same place. So is this a problem? Well, why aren't they developing? Why aren't these contractors and subcontractors developing? And what does it mean for our economy? Well, if they're not developing, our economy is not developing, our industry isn't developing, and our industry isn't transforming either. There are a number of reasons for this. Skills, training, and a number of things which can be addressed quite easily. But the fundamental problem and the most compelling reason why this is not taking place is due to endemic poor payment within the industry. And this poor payment obviously affects cash flow. It affects the ability of contractors and subcontractors to execute contracts, which they're currently busy with. It affects their ability to tender for new work and get new contracts. And in severe instances, it results in those contractors being placed under business rescue, and in even more severe cases, they go into liquidation. And the impact that has on our industry is that our industry shrinks, we lose jobs, and the CIDB cannot achieve the aims that it's supposed to be achieving. It cannot fulfill its purpose. So in terms of these indicators, the most recent indicators, which are the 2014 indicators, show that only 42% of contractors are paid on time. That's within 30 days, and that is across both the private and public sectors. This is worse than the previous two surveys, which record 44% and 48% respectively. So the problem's getting worse. Every year it's getting worse and worse. And in some provinces, such as the Eastern Cape, that percentage is in the single figures. The main culprits of this appear to be the public bodies, the national and provincial departments, followed by public corporations. And it's very easy to say, well, it's only happening in the public sector. But in the private sector, it's just as bad. In the private sector, only 41% of contractors are paid on time. So it's just as bad. Unfortunately, the industry indicators don't publish any statistics on payment to subcontractors. So we don't know how bad it is once it gets below the contractors. But what we do know is that the primary payment mechanism between contractors and subcontractors is a pay-when-paid provision. So we can presume that it's far worse for the subcontractors and the suppliers. They're not getting paid within 30 days at all, probably. They're getting paid much later. So currently, the only legislation which we have in place which addresses this, and whenever this is raised at the CIDB level or Public Works level or at the Treasury level, is that we have the Public Finance Management Act. And every time the issue of payment security legislation in South Africa is raised, the response is, but we already have legislation in place. We have the Public Finance Management Act. The problem is that this only applies to public bodies. It doesn't apply to the private sector. And secondly, it doesn't apply to construction contracts. It doesn't deal with the specific requirements that construction contracts need. The right to regular payments, the right to payment certificates, the right to suspend for non-payment. It doesn't deal with that. And so it's not really a suitable answer. It doesn't really address the needs of the construction industry. Moreover, it's not working. There was a recent circular which was published by Treasury dealing with this, but recognizing that there's an issue here. And they published the circular stating that research conducted by the Office of the Procurement Officer revealed that inability of organs of state to pay suppliers within the prescribed period of 30 days has dire implications on small, medium, and micro enterprises and other businesses that supply government with critical services. And the directive directs that all suppliers should be paid within 30 days. It sets up a hotline for disgruntled suppliers to phone in and have their invoices paid, but it's still not working, and it's not addressing the issue of non-payment. In 2015, the CIDB published a set of proposed prompt payment regulations, which we'll look at a little bit later. Unfortunately, the enactment of these regulations has stalled. I've heard various reasons for this. I've heard that it was referred to the Department of Justice, and issues are raised with regards to the constitutionality of the prompt payment regulations or certain parts of it. What I do know is that, for certain, is that following the comments which were received in respect to the prompt payment regulations, the public comments, there was a severe backlash from some of these state-owned enterprises, Escoms and Transnets and other organizations owned by the state, with regards to certain clauses in these proposed prompt payment regulations. And that seems to have scuppered the process. And they haven't been brought into law, and it doesn't look like they'll be brought into law for some time still. What does this bad news or bad payment mean for the CIDB? Well, in short, although the CIDB is trying its best and issuing various standards and doing all that it can do, it cannot achieve its purpose. It has its hands tied. Without payment being made, it cannot transform the construction industry. And until there's payment security legislation in place, the CIDB just simply will not achieve its objectives. The next thing I'd like to talk about is the increased use of standard forms and how this has affected our industry. So since the CIDB standards of uniformity were released, many employers have moved away from their own in-house bespoke conditions of contract and have adopted standard form contract. So if we go back 10, 15 years, a number of employers, not only in the private sector but also the public sector, had their own in-house forms of contract which they used. That is no longer the case. There are a handful of employers which still use their own in-house conditions, mostly in the mining and petrochemical space. But by and large, most employers in South Africa, both public and private, now use one of the 4 prescribed standard forms: the JBCC Principal Building Agreement, the GCC 2010 or 2015, which is the latest update, the FIDIC 1999 suite, or the NEC 3 suite of contracts. These contracts, the international contracts and the local contracts, have exhibited a shift in recent years to become more onerous on contractors. And our local forms are no exception. What we've seen is that there's been firstly an introduction of time bars across all contracts, and in some contracts even worse than others. So firstly, there are time bars on notices for claims, time bars on claims, and in some instances time bars on referring disputes. So the NEC, for example, has a series of time bars which are placed on the referral and submission of disputes, notification and referral of disputes. Not to be outdone, our local standard forms have even introduced further time bars. So something which is becoming a bit of a characteristic here in South Africa is the impact warning clause. I've taken the name from some famous amendments to the FIDIC form of contract, impact warning. It's not called an impact warning in the GCC 2010 or 2015. But essentially these clauses state that if the engineer issues an instruction to the contractor believes that the instruction will give rise to a variation, the contractor must give notice, an impact warning notice or something similar, within 7 days, failing which the contractor will not be entitled to any payment or any additional time as a result of the instruction. This particular term, the impact warning, came out of the Eskom amendments to the FIDIC conditions of contract, and we see a very similar clause in the GCC 2010 and 2015, and we see it being written into a number of other contracts at the same time as well. The question is do they work? Is it good to have time bars? Is it good to have impact warnings? Well, the anecdotal evidence is that they don't. They seem to be, on the anecdotal evidence, they seem to be an experiment gone bad. On the long-term power plant contracts at Medupi and Kusile, very onerous conditions were imposed on the contractors. At first, the contractors didn't comply, so the time bars did work. But very soon, the contractors realized that they were going to be there for quite a while, and if they didn't comply, they'd lose lots of money and they'd be penalized. So what they did is they employed armies of claims consultants and lawyers, and notices were drafted and compliance was achieved. And what happened is that because the time periods are so rigorous, that various claims were notified without knowing whether they'll be claims or not, without understanding what the effect of the event will be. And once they were submitted, the various layers of time bars which had to be complied with, claims were submitted without knowing what the full impact would be. And updates were submitted, and eventually there were thousands and thousands of claims on contracts. And we've seen from the contracts we've been involved with that the claim numbers go into the thousands. Eskom, from what we've seen in our experience, have said, well, this can't work. It can't operate like this. We cannot be faced with thousands of claims going to dispute. This is not how we should be executing contracts. And they've taken a much different approach to what's stated in the contract. So over time, although they may have thought it was a good idea to start with, they've actually taken a different approach more recently into how they manage those contracts. And they don't look for strict compliance with the contract any longer. In fact, if any of you watched Carte Blanche on Sunday, you'll see that they actually give their money away now. So or allegedly give their money away, should I say. So the answer is, from my side at least, I don't believe they do work. And I think that if you want to have a claims provision and you want to understand what the true effect of a claim is, and you want to deal with claims properly, well then you should either have longer time periods for notice and submission of claims or not have time periods at all. And claims should be submitted as and when the amounts are known and when the delay is known, so that we understand exactly what the full effect is. And I've put a quote there. Ronan Champion, who wrote a paper on claims, variations, and unintended consequences, which is published on the SCL website, said that these provisions are draconian, a likely source of contention, and represent a shift away from collaborative working. Time bars are more trouble than they are worth. And I agree with that sentiment. I think that time bars have the opposite effect of what people think they're going to have. It may have been a few years ago when, as I said in my introduction, people didn't use the contract that you could catch somebody out with a time bar. But the more people are familiar with the provisions of contracts, the more they understand exactly what's going on in the contract, then the more likely they are to comply with those provisions and submit notices and claims. Yes?
If I just interject there, I'm sorry to do this here. I think the point here is that they've lost the sight of what the real purpose of the time bar is. The real purpose of the time bar is to put the party receiving the notice in a position where they can mitigate the effect of the event. And what has happened, particularly on the Eskom contracts, is they've turned around this. The intention is to trip the contractor out. And that's the problem. That's where the great waste comes from. So you've got to apply them with care and with a pragmatic approach. Doing what they did on contracts was just the opposite. What they were doing was effectively throwing a gratuitous bucket of petrol into a already blazing situation.
Yeah, no, that's true, and that's exactly what's happened. They're there to trip up contractors, and what happens is you end up with a very adversarial and overly legalistic approach to contract administration, is what happens. The other general development that we've seen with in standard form contracts is that there's been an increased emphasis on programming. So for a long time, the NEC and FIDIC have placed emphasis on the program, and we understand exactly what those contracts say when they deal with the program. So in 8.3 in FIDIC, we understand that the program is there to manage the performance of the contractor in executing the works, and can be used if the contractor falls behind program to catch up under clause 8.6. The accepted program under the NEC is there to assess the effect of compensation events. So it's there as a change management tool. So we understand exactly what the program is there for with respect to those contracts. What we've seen in the local forms is that they too have decided to bring in programming provisions, but it's not altogether clear exactly what the purpose of those programming provisions are. So the GCC 2010 and 2015 seems to be a bit of a mixture between the NEC and FIDIC, and they don't seem to be too clear on exactly what it is. So we use the program to manage manage the performance of the contractor and manage change control. And the JBCC doesn't seem to know where it's going with the program, whether it's a change control mechanism or whether it's there to manage information flow. So it's a slightly different approach. Although the JBCC is a bit clearer on that, it's got some very specific requirements, cash flow forecasts, management of information, those kind of things, which are quite clear. What's happened with that, and one of the developments we've seen, is that there's been an increase in delay experts and the role that delay experts play in contract administration. Most contracts now require a planner on site, a full-time planner on site, and that is then backed up when claims need to be submitted with a forensic expert being employed to look at the program and substantiate an entitlement to claim an extension of time. Now, in certain respects, this is good. It's good to know exactly what the effect of a delay is, but it can also frustrate the process as well. Now, most of you will know this, but when you get into a programming exercise, basically you've got a nice picture that can be painted in many different ways, and there are different techniques which can be employed to show different effects and show different entitlements. So you often get into a situation when you submit a claim under a contract or when you get to dispute resolution, that the first argument you have is about the delay analysis technique that's used. Is it a time impact analysis, or have you used some other form? And is it the correct analysis to use in the circumstances? Should we have not used an as-built analysis versus an as-planned analysis? And it's all about substance over form. What happens in those situations is that we're distracted from the real cause of the delay. What was the factual event which gave rise to the delay? Were we stopped on site? Was there a delay or not? That's the first line of inquiry, not what the actual impact is. And often you get into these side arguments, which are there really simply to delay and frustrate the process, which is unfortunate. But in many instances, those delay experts add value to the administration of contracts. So the effect of these general developments in standard form contracts, and obviously it's very, very high level comments on these standard form contracts, is that the consistent use of standard form contracts has been good from the perspective that all of us involved in the management and administration of contracts are now becoming familiar with the concepts in these contracts. We all understand what a time bar provision is. We all understand what the programming requirements are. So that is good. It's good from that perspective. That said, there's no doubt that the administration of contracts has become adversarial and overly legalistic. Going back to the example of the Eskom contracts, when these layers of time bars are put into the hands of the contractor and the engineer, and you throw in a couple of other clauses which are deal with fairly complicated legal issues, like, for example, an obligation to mitigate the effects of an event giving rise to a claim, and exactly what constitutes mitigation. It's like putting a loaded gun into the hand of a child. A very difficult situation to deal with, because here we have people throwing around legal concepts between each other at site level, which is not a good thing. It's not good because the idea behind a construction contract is to facilitate the execution of a project and to have something built and something done, not to enhance your legal skills and to write lots of letters. So some of the other things which have sort of been byproducts of all of this is that the number of claims consultants is growing, and we see, the establishment of a number of international claims consulting practices locally, and a number of new claims consulting practices as well. And also the number of construction lawyers is growing. So this is a growing area within the industry. A number of the large firms, if not all of the large firms, now have construction law departments. Some of them have had construction law departments for a long time, but this is also a more recent development. And we have some firms, some international firms, which are construction law firms, now establishing themselves in South Africa as well. So it's a growing area in our law. The next big development over the past 15 years has been the growth of contractual adjudication. I say the growth because adjudication isn't something which is new. It's been around for a long time. All of our standard form contracts provide for adjudication. We don't have any statutory adjudication, but we have contractual adjudication. All of the standard forms provide for it, and a number of the bespoke contracts also provide for it. So, we see in some of the subcontracts, for example, they also have subcontract adjudication, and some of the in-house contracts as well for the mining houses and petrochemical employers also have adjudication. The sort of dispute resolution process of adjudication as we know it sort of first appeared in South Africa in the 1980s. The GCC 1982, and after that the Principal Building Agreement, the JBCC Principal Building Agreement in 1991, had mediation clauses. They referred to mediation, but the opinion of the mediator, which had to be obtained following a process of submissions from both parties, the opinion of the mediator was binding as a matter of contractual obligation. And there were a number of cases which dealt with it. The first one was the Blue Circle versus Klerksdorp case, where the mediator was Philip Lutz, and the court there refused to enforce the opinions of the mediator. But a few years later, there was the Stocks and Stocks case. Again, there were a number of decisions of the mediator, and in that case, the court enforced the opinions of the mediator as they were binding as a matter of contractual obligation. So they did that by way of specific performance. They said, well, the parties agreed that the opinions would be binding, and therefore we will enforce them. That's a different approach to other jurisdictions. In the UK, for example, and Andrew and John will probably talk about this a little bit later, but in the UK, when adjudication first came out, before they had statutory adjudication, they couldn't enforce it because the courts there generally don't deal with issues of specific performance. They'd rather look to other remedies in contracts, such as damages, as opposed to enforcing a party to comply with its contractual obligations. Our law is slightly different, so we were able to enforce that in those early cases. The more recent cases have also reinforced that. So the two sort of key cases here, which were the 2013 cases, was the first one was Esau Frankie versus Bombela, which dealt with some works on the Gautrain. And then after that, the Tubular versus DBT decision, both of them dealing with the FIDIC contract and decisions of the DAB, and both deciding to enforce the decisions of the DAB as a matter of contractual obligation. In the Tubular case, the court said, I therefore find that the terms of the relevant contractual provisions are perfectly clear. The parties are obliged to promptly give effect to a decision of the DAB. The issue of a notice of dissatisfaction does not in any way detract from this obligation. While such a notice is necessary where the dissatisfied party wishes to have the decision revised, it does not affect that decision. It simply sets in motion the procedure in which the decision may be revised. But until revised, the decision binds the parties and they must give prompt effect thereto. So there, in that particular case, the argument was put forward that, well, we have this decision, we don't have to comply with it because we've issued a notice of dissatisfaction, and the court said, well, that's no good. You still have to comply with it as a matter of contractual obligation. So our courts have really taken a robust approach to enforcing adjudicators' decisions in contractual adjudication. Okay, and that's quite a good thing because, as I said, in other jurisdictions, pre the enactment of statutory adjudication, you couldn't, generally speaking, enforce the decisions of adjudicators. You have to have statutory adjudication in order to give effect to those decisions and in order to have a way of enforcing them. The area of contractual adjudication is growing as well. There are a number of recent decisions, and it seems to be expanding. So we have two similar cases, Transnet and Group 5, and Eskom CMC, the famous CMC now after Sunday's carte blanche episode, dealing with pretty much the same thing, the appointment of the adjudicator under the NEC 3 conditions of contract, under option W1. These are also interesting cases from the point of standard form contracts, but there basically both court decisions have confirmed that the adjudicator is not appointed on an ongoing basis, and that it's an ad hoc adjudication, and that you can change the adjudicator as you change disputes. There was a belief for a long time that once you had an adjudicator appointed, that adjudicator was appointed until all of the disputes under the contract had been resolved. But those two cases have basically removed that understanding and have confirmed that adjudicators are appointed on an ad hoc basis per dispute. So the parties are free to agree to a new adjudicator as you go along. And these decisions are also, there are a number of other decisions as well. They are also appearing in our neighboring jurisdictions as well. So there's a recent case under the fitting conditions of contract, the Road Authority versus Cushing. It's a Namibian case where the employer brought an application or some form of application to the DAB with regards to a particular referral. The referral was for approximately 50 million Namibian dollars, and they made a submission and asked the DAB to rule on its own jurisdiction. They said this dispute is far too big and complicated for the DAB, and we do not believe that you have jurisdiction. The DAB disagreed and said we do have jurisdiction. They immediately ran off to court, the employer, and sought to review the decision of the DAB on the basis that the $50 million dispute was too big and complicated for the DAB to deal with, and the court said, no, we disagree. The DAB has jurisdiction to decide all disputes, and it doesn't matter how big or horrible the disputes are, they must deal with them first before going to arbitration. So some interesting cases which have developed recently. So with that, and looking at the approach of our courts, the question could be asked, do we even need statutory adjudication? Is it something which is necessary? We have contractual adjudication. The courts are enforcing the decisions of adjudicators. Things seem to be going well. Do we even need to have statutory adjudication in this country? And there are a couple of other things which have developed as well. So we have, as Vaughan was saying in the introduction, we have the Construction Adjudication Association of South Africa, which was formed in 2013. And the aim of the association is to promote and encourage the use of effective adjudication as a form of dispute resolution in South Africa. And it does so by providing accessible, informal, and regular and open platform to discuss adjudication and adjudication issues. So that's the one development. The other development is that there have been some competent adjudicator nominating bodies which have either come into existence or improved themselves. So we have, for example, the ICESA, where they deal with the appointments under NEC contracts, and by comparison to other adjudicator nominating bodies, they comply with the time period stipulated in the contract. Those of you involved in adjudication will know that when asking to have an adjudicator appointed, especially under the NEC 3 contract, the adjudicator nominating body is supposed to do so within 4 days. So if you ask for the appointment on a Thursday, it should be done by Monday the following week, and that very rarely happens. The ICESA has made it a point, as they are the adjudicator nominating body for the NEC conditions, to do the appointment within the prescribed time period. And then also we have the University of Pretoria adjudication course, and we also have the course which Fergus was alluding to a few minutes ago as well, which will start next year. So we have a number of good developments aimed at growing the practice of adjudication in South Africa. But still, do we need statute? The problem is that the current framework doesn't extend adjudication to all of the role players in the construction industry. Although the standard forms provide for adjudication, and although we may find it in some of the subcontract conditions, it isn't a matter of right. You don't get it as a matter of right. And in some contracts, the employer writes it out, or the contractor writes it out, and it's not extended to everyone in the construction industry. And we come across it fairly regularly where there's a dispute, the dispute resolution provisions have been changed, and there's no access to adjudication. So it's not a blanket right to have your matter dealt with by way of adjudication. That's the first point. And well, what does that mean? Well, it means that even at the lowest levels, down to suppliers and subcontractors and subcontractors, there is no right to refer disputes to adjudication, and there is no right to have this effective, efficient, and short dispute resolution process, which can be dealt with quickly and effectively. Also, it does not regulate adjudicators, adjudicator nominating bodies, and education programs. So we have no regulation of that at the moment. That means that anyone can act as an adjudicator. It means that an adjudicator nominating body can start tomorrow. They can do what they like. So with statutory adjudication, what typically comes along is that in order to operate as an adjudicator, in order to operate as an adjudicator nominating body, you have to meet certain requirements. And there is a quality control, if you like, placed on that process. And in order for these things to be effective, you need to have adjudicators who understand what they're doing and understand what the process is, so that they give binding decisions which can be enforced. The UK courts have gone as far as to order that adjudicators pay back monies which were paid to them as fees if they don't give a binding decision. So in those jurisdictions, there is control. Here we have adjudicators who give decisions which nobody understands what they mean. It happens from time to time, and you can't enforce it. You end up going to court. You've got no chance of enforcing it because it's not definite in what it's supposed to say. Adjudicator nominating bodies, and I've touched on this already, generally don't comply with the time periods. So the adjudication process is being delayed. It's already long by comparison to other jurisdictions. We have, generally speaking, a 3-month adjudication process, but that can be delayed by a 2-week appointment. You can add another 2 weeks to the process if the adjudicator isn't appointed on time. And then we have education programs. We have various education programs out there, but do they qualify you to act as an adjudicator? The organization giving the program says they do, but how do we know? How do we know whether a 1-day program is good enough or a year-long program is good enough? Nobody's gone and done any quality control to make sure that the programs are satisfactory and that they train people properly. So that's some of the issues. And despite that, despite the approach of our courts, and despite all the good things that have happened, I still think that we need statutory adjudication in South Africa. The other area which has grown and shows the sort of breadth and depth of construction law, if you like, is the number of tender challenges which have taken place. So in South Africa, we've had significant changes in procurement legislation over the past 15 years. The key pieces of legislation which have changed are obviously the Constitution. We have something called the Promotion of Administrative Justice Act. We have the Public Finance Management Act. We have the Preferential Procurement Policy Framework Act, the Broad-Based Black Economic Empowerment Act, the CIDB Act, and a few more other acts as well. What this has meant is that when it comes to public bodies awarding tenders, there is a number of regulations which they have to comply with, and it is a minefield. They find it very difficult to comply in many instances, and this leads to a number of challenges on those awards. And it's summed up best by the judgment in the recent Massey case, where the court stated that these awards often give rise to public concern. They are a source or fruitful source of litigation. Courts are swamped with unsuccessful tenderers that seek to have the award of contracts set aside and of the contracts to be awarded to them. The grounds on which these applications are based are many. Sometimes the award has been tainted with fraud or corruption, but more often it is the result of negligence or incompetence or the failure to comply with one of the myriad rules and regulations that apply to tenders. And what's happened in the space of construction law is that this has become a specialist area of practice. And a number of you would have been through these processes or been part of the process, whether you had been awarded a contract and one of the other disgruntled contractors had gone to court to review and set aside the award. This has become a specialist area and something which is growing. Is it good or bad? Well, it's not unique to South Africa. This is something which we find all over the world and in other jurisdictions with the EU regulations in the UK. The public procurement regulations in all countries allow for disgruntled tenderers to have access to court to challenge the award of public bodies of tenders. So that's important because it achieves transparency and cost-effective procurement, so that's a good thing. But unfortunately here in South Africa, I think that the high incidence of tender challenges is concerning because it points to something a little bit more than just disgruntled tenderers. It talks to potentially negligence and some of the other things referred to in the Massey judgment as well, fraud and corruption and other issues as well. Okay, so those are some of the big developments over the last few years, and there have been a number of other ones as well. The way in which contracts are funded, projects are funded, different models, there have been a number of developments. I've just focused on a few. So the question is, what does the future hold? So if we were to say, well, what can we expect in the next few years? Well, firstly, I think one of the things which we need to talk about is the prompt payment regulations. So the blight of endemic poor payment needs to be dealt a decisive blow. If we want to achieve what the white paper set out to achieve, if the CIDB wants to achieve its goal, its purpose, its mandate, it cannot be done until there's prompt payment or payment security legislation. It just cannot be done. Until that issue is addressed, and then nothing else will address it. It's not something which we can all get together and say, right, let's sort this problem out. It will not work until there's some form of legislation in place. The proposed regulations, which were published last year, provided for a whole bunch of things, but some of the key factors were there was a prohibition on conditional payment clauses, so things which would be hit by that are pay when paid provisions and subcontracts, but also in financed agreements where financiers appoint a lead technical advisor to certify payments to the main contractor, and that would be a condition to payment. Those would also be hit by that particular prohibition. They provide for regular payments within a defined time frame, which is important because in a number of contracts, and you may not think this, but most people look at main contracts and say, well, we have monthly payments, that's how it works. But a number of contracts don't, particularly supply contracts and subcontracts. And if there are no regular payments, the default position is that you can't be paid until you finish the work. So people have to execute contracts, and if they're delayed and they go into 6 months, a year, they can't get paid. So there needs to be a right to regular payments. Suspension of construction activities for non-payment. Some contracts provide for this, but as a right, it's a very powerful right for contractors to say we are not going to work any longer if we haven't been paid, particularly in respect of some of the public sector contracts and even some of the private sector contracts where the money runs out. if you don't have the right to suspend, your next right as a contractor is to terminate. And that may not be a satisfactory remedy. You may not want to terminate. So that would introduce that as a right. A prohibition on the withholding of payment without notice. So payment can be withheld, but it's subject to a notice being issued by the employer or by the contractor, advising how much is going to be withheld and why. That would then form the basis of a dispute if a dispute arose from that withholding notice. Entitlement to payment of interest on late payments. The CIDB regulations go to town a bit on this. They've got some fairly high interest rates put in there, and I think that may have been the subject of some fairly fierce criticism, criticism. But there's an entitlement to interest, and then also, and importantly, the introduction of mandatory statutory adjudication of all disputes. So if we were to look at the adjudication side, if that was introduced, then that would obviously extend the benefits of adjudication to all. Subcontractors, suppliers, and in the current form, to professionals as well. So anybody involved in construction procurement would be entitled to refer their disputes to adjudication. And that would require growth in the number of adjudicators and the adjudicator nominating bodies in South Africa. As I said earlier, these regulations have been stalled. Some people are saying that they'll be out next year. I've heard that they've been referred to Treasury, and they're sort of bouncing around between different government departments at the moment. There are a number of interest groups who are lobbying to have them enacted as fast as possible. Unfortunately, we just don't know how long it will take. And possibly the next thing I'm going to talk about may sort of give us an indication. Well, the International Arbitration Bill was tabled earlier this year on I think it was the 28th of April this year. The International Arbitration Bill is the product of a report published by the Law Commission in July 1998, where they recommended that the model law, the UNCITRAL model law, be adopted for all arbitrations. So there's a potential indication, nearly 20 years to get there. So we might be talking about the prompt payment regulations in 20 years' time. Let's hope not. So what does this mean? Well, currently we have the Arbitration Act, which is over 50 years old. The Arbitration Act, in its current form, allows for extensive judicial interference into the arbitration process. What does that mean for those of you who are not involved or familiar with arbitration? What it means is that when you're involved in the arbitration, you can run off to court quite often and get the court to intervene in what the arbitrator is doing. And it frustrates the process, it delays the process, and even when you get to the stage where awards are published by the arbitrator, the grounds for review are fairly wide, and you are able to review the award of the arbitrator and introduce further delays to the process. And what that has meant locally is that, particularly in the construction industry, most role players have lost favor with arbitration. It's not seen as a satisfactory process to resolve disputes. Of course, it's still satisfactory in certain types of disputes where there are large sums of money and it's worth the time and cost associated with it, or where there's an international arbitration where you're arbitrating with somebody from a different jurisdiction and you need to have an arbitration award to be able to enforce that arbitration award in their jurisdiction. Then it becomes a viable option. But as far as domestic arbitration goes, generally speaking, arbitration is not looked at favorably. The proposed International Arbitration Bill aims to bring international arbitration to South Africa. And the timing is quite good, because the recent case of Zongi versus Kamato Copper Company, the Supreme Court of Appeal said that the South African courts not only have a legal but also a socio-economic and political duty to encourage the selection of South Africa as a venue for international arbitrations. That sounds quite exciting. International arbitration venues are Singapore, London, Geneva. That's usually where you associate international arbitration venues. So talking about South Africa as an international arbitration venue is exciting. International arbitration in South Africa will only foster a comity amongst the nations of the world, as well as international trade, but also bring about the influx of foreign spending to our country. So this is good. So the bill has been tabled. It hasn't been passed into law yet. I'm not sure of the progress with it, but it has been tabled. And the timing is also good from a number of other viewpoints as well. As Fergus was saying, the Chartered Institute of Arbitrators has recently established their branch office in South Africa, an international organization. So we'll have access to international arbitrators and South African arbitrators. And then also at the end of 2015, the China-Africa Joint Arbitration Center, or CAJAC, was established with arbitration centers in Johannesburg and Shanghai. It's an initiative which is being pushed by AFSA, and the idea is to have Johannesburg as an international arbitration center for disputes which may arise between African companies and Chinese companies, and vice versa with Shanghai. And they will draw on the arbitrators based locally and within Africa and within China to resolve those disputes. And they're in the process of drawing up a specific set of arbitration rules for those arbitrations. So that's a very specific effort and endeavor to bring certain types of arbitration to South Africa. So those are some fairly exciting initiatives. And South Africa is gearing itself towards international arbitration. So those are good things. The next question is, well, are there any other possible changes? Well, the changes which we'll need, and whether we get them or not, I don't know. But if we're looking at these other possible developments, and if we were to say, well, we could have statutory adjudication, we could have international arbitration, the next question is, will they work? It's all good and well having an International Arbitration Act, but will it work in South Africa? What you need in order for arbitration to work, in order for adjudication to work, is you need to have a backbone and support structure which assists that. And we have arbitrator nominating bodies, we have arbitration associations, we have adjudication associations, we have training programs. All of those things are very good, and we have a framework in place. But do we have the court structure to back it up? If we're involved in an arbitration, an international arbitration, and one of the parties decides to run off to court to get to remove the arbitrator, will it work? Will it work in the current circumstances? And the answer is probably not. Our courts are slow. They're a bit of a lottery at the moment. And I think a lot could be done by changing the civil procedure. And I think that would have to be considered going forward. The Wolf reforms in the late 1990s in the United Kingdom changed many things with regards to the enforceability of arbitration and in terms of adjudication as well. We see some positive things. At the moment, there's court annexed mediation in the lower courts, which is a good thing. And mediation, when it works, is an exceptionally effective and the most effective way of resolving disputes. It is a very good way, very quick, very cost efficient. Unfortunately, it doesn't work as often as it should, but if it, even at small percentage numbers of success, it still has a very valuable and important place in resolving disputes. So we could see some civil procedure changes, and who knows what would be ideal. Whether we ever get there or not is something like a technology and construction court or something close to that, where we have a specialist court where this industry can go to court to resolve their disputes, whether it be enforcing adjudicated decisions or dealing with issues arising from an international arbitration. But if it's of a construction nature, then it can be referred to a specialist court with specialist judges who understand the types of disputes which relate to the construction industry and deal with them efficiently and effectively. The last possible change, which may seem quite strange, is that we may see an increase in collaborative contracting. When everything is cyclical, when we see a spike in adversarial contracting, and we see a spike, as we're seeing at the moment, in disputes, numbers of disputes, adjudications are increasing, arbitrations are increasing, very often people revert to the opposite of that and look at different ways of doing things. What we're seeing internationally is that there's a big growth in collaborative contracting. There are a number of standard form contracts. The Alliance Framework Agreement, for example, which has been drafted by David Mosley. A number of initiatives to bring about standard form contracts for collaborative working and promoting alliancing and framework agreements as a basis for securing construction services. So perhaps in the next few years we may see a change and a renewed interest in collaborative contracting. Many of you will know that a few years ago, before 2008, there was a growing interest in collaborative contracting, with a number of the mining houses in particular signing long-term framework and partnering contracts with contractors in order to secure the benefits of alliancing and collaborative working. So what that means is that construction law in South Africa is growing. It's dynamic. It's changing all the time. And we all need to be keeping abreast of what's going on. So initiatives like the Collective Wisdom are aimed at that. It's aimed today at ensuring that all of you are attending actually are up to date with what's going on both locally and internationally. So thank you very much, and I hope you enjoy the rest of the day. Are there any questions?